Good afternoon, everyone. This is 𝗪𝗫𝗀𝗻 from 𝗨𝗪𝗁. Today, we are back with this webinar on IPR. Today's topic, where in today's webinar, we are going to deal specifically with the topic of patents. Today, again, we are joined by our very own expert, Mr. Saransh Chaturvedi, who has previously done webinars on IPR topics. Today, he'll be taking us through the nuances of filing of patents and how does this whole uh, area of patent law works. So I won't take much of your time, and I'd request Mr. Saransh Chaturvedi, who is an advocate, who is a practicing advocate in High Court of Allahabad, and has an expertise and interest in the area of IPR, to please take ahead the session. Thank you so much, sir, for joining us.
Thank you so much. Thank you so much. And thank you, 𝗨𝗪𝗁 team, for having me here once again. Before starting, let me share my screen. Yeah, is it visible?
Uh, yes, it's yeah,
Yeah, now it's perfect, isn't it?
yes.
Yeah. So the topic of today's webinar, the getting ahead with your patent application. I don't know much about the participants and what are all the qualifications of the participants, but I assume that this webinar is being attended on, and all the attendees do know the basic nitty-gritty and do know the basic things of IPR. Means they know what is patents, what are prior arts. Since this is the basic things, and we are getting into an advanced analysis of how we are getting ahead with the patent application, it means that we know what all patents are and how to deal with this all patents and what are claims, specifications, everything they know, right? So I previously assumed that, but still I have made my PPT in a very self-explanatory mode, so that all students and attendees can even have a look on this, and if not able to understand some of the basics, can raise questions and can raise hand and can ask questions answer. So without much wasting time, we should start with this getting ahead with our patent application. Now basically what happened is that when you have a patent application, you have done with you have done with your search, and now you have in your mind, you know that this is a patent which you are now going to file in a patent office, right? So now after this filing procedure starts, there are a lot of procedural nitty-gritties that is specifically mentioned in the patent rules as well as patent acts with regards to the patent office in India. Nitty-gritties with respect to date of filing, with respect to examination, the specification, the opposition, and all sort of things are there, which are which forms a part of a patent prosecution in India, and which are primarily dealt by the patent office, right? So before starting, let's first of all get into what is your date of filing. So you, as I told you, you have your patent application ready with you, right? So now you went to the patent office. Either you are submitting it online or you are doing it offline also. So now you are going and you are having a date of filing and priority date. So now what is all about date of filing and what is all about priority date? Date of filing, as the name suggests, is the date when the patent office receive your application. It's, I think there should not be any doubt in this, because whenever you will go to a patent office or will file an online application, the date on which you are filing your online application is the date of filing, right? So date on which the patent is filed in the respective office is the date of filing. Confusion starts when you see a word known as priority date. Date of filing and priority date are two different things. I will explain you all the intricacies which is associated with this date of filing and priority date. Now, when you are trying to deal with this priority date, the priority date and the date of filing means that you are claiming your this date as your first date of filing. When you are claiming your first date of filing, that date becomes your priority date. Meaning thereby, suppose let's say I went to patent office and I submitted my application on 1st January 2021, right? So 1st January 2021 will be my date of filing. This is clear, right? Now I will be dealing with other specifications also. Now let's say you file another application that is based upon this application only, which you filed on 1st January. In that, there will also be a date of filing, but in that date of filing, you will claim your priority date on 1st January. It means your priority date is the date which defines your establishing the novelty of your invention. Uh, Again, what are all novelty? What are all the prior art is? I assume that you all know it. For those beginners, novelty and prior art means that you are claiming that this invention was not conceived in the world before 1st January 2021, whenever you are filing it. So this 1st January 2021 becomes your priority date. You are claiming your priority. You are claiming that this invention, you are claiming your base of this invention, that this invention on 1st January 2021 is my priority date. So that becomes a very important part, because this date and this date of filing is sometimes used interchangeably by various at various places. Why it is used interchangeably? So when you are having one date of filing, let's say you are having 1st January 2021, and you don't file any applications after that, so that date of filing will be a priority date. See, it means priority date is equal to date of filing. In this case, when you are having only one application, let's say when you are filing multiple applications in your invention, then the priority date will be the first filing date, the earlier filing date, which is the first one, right, on 1st January, after which, even if you have filed 10 applications in the whole year, the priority date will always be the 1st January 2021. That is a clear concept when you are filing multiple applications, or even if you are filing two applications, right? So date of filing and this priority date is different in the scenario when we talk about multiple applications. When we are only having one applications, the date of filing and the priority date will always be same. Priority date will establish your invention novelty, which means you are claiming that before 1st January 2021, when you are claiming a priority, as I gave you an example, before 1st January 2021, you are saying that this invention was not preconceived and this invention is new. So if I went to patent office, let's say on 1st February, so you can come and you can say that since I filed it 1st January and the invention that you are filing on 1st February is same to my, since I have filed earlier to you, I will have the priority. This is the basic concept. I think this is a simple general basic concept of date of filing and priority date. As I told you, in case of only one application is filed, the priority and the date of filing will be the same. And in multiple applications, the priority date will be the earlier filing date, right? Two more application for similar invention, the application will have the application with an earlier priority. As I told you, the example of February, when somebody will come in the month of February, you will claim that your priority was earlier, that was in January, so you will have your precedence over your invention, right? Section 53 says, talks about term of invention. Section 53 of Patents Act, term of invention is 20 years from the date of filing. Now you should be very clear that the date of filing in what is written in section 53 does not mean whatever date of filing. It has to be understood in the terms of the earlier filing date, right? So term of patent was 20 years from the earlier filing date. So let's say, again, I give you an example. 1st January 2021 is your date of filing, and rest you file all patent applications, all sort of different applications you file, which we will be discussing afterwards. So since you have filed it on 1st January 2021, and even if you have granted your patent in, let's say your patent has been granted in 1st January 2022, so your term of patent will not be calculated by 2022, but by 2021 1st January, the earlier date of filing. That is called as the priority date. You are having the priority date, so your term of patent of 20 years will be counted from this priority date. So you have to be very clear about this earlier date of filing and priority date. You have to be very clear, because ultimately when we are dealing with all examinations and PCT applications, this date of filing and priority date will be used at multiple times. So make your concept very clear with this. The date of filing and priority date, what are all the differences and what are all the intricacies associated with them, the term from the earlier filing date. Now come to the provisional and complete specifications. Now what are all the provisionals and complete specifications? Let's say you have an invention in your hand and you think that this invention is very good and this invention is worth of having a patent, right? But you don't know what all are the intricacies are, and you have not filed or you have not thought about all the claims, right? So you can file a provisional application in the patent office. Section 9 provides with both the specifications. So you have not fully conceived, invention is not fully conceived. You can and you know that writing the whole claim specifications will not be possible for you. So you file a provisional applications is an option for you in a patent office. Now what is important is what are the demerits and merits of a patent application. Before going into that, you have to understand this is filing of provisional application is not mandatory. If you know, if you want that, okay, fine, you're much confident that your claims are ready, you directly go for filing a complete specification. Provisional specification is not mandatory, is an optional part. And what are all the merits and demerits of a provisional specification? Now, when you are, let's say again, I give you an example. Let's say on 1st January I thought about an invention, right? And I think that, okay, fine, this invention can be patented in India, because all things are applicable. These inventions are getting into inventive steps, all things are there. So you think that, okay, fine, I need to make claims. But now you are very confident that, okay, fine, whenever I will file this application, that will be granted. Again, the importance of date of filing and priority date will come. So what provisional specification will give is that when you are filing a provisional specification, let's say I thought about an invention on 1st January, and I thought, okay, fine, I should file a provisional specification. So on 1st of February, I file a provisional specification. Now, again, coming back to the priority date, the priority date will be your 1st February. What is an important? Let's say another person comes up with the same idea in the month of June, even with complete specification. Still, you can claim that your priority date is 1st of February, so you can claim precedence over your invention. That is what an importance of provisional specification is. You know that there can be an invention and you want to save your dates, so that no other person could come and could take your inventions, or to take his inventions and get it patent. So it's better to take it earlier, and it's better to give the provisional specifications so as to clear, or so as to fix your priority date. Now, even if you file a complete specification, as per the rule, you have to file a complete specification within 12 months of a provisional specification, right? 1st February, like you filed, so 1st February 2022, you have to file your complete specification before that. What happened? First of all, in provisional specification, I told you that your date of filing and priority date is getting fixed. You are getting priority over all the precedents, right? That is very clear. So, and also an important part is that you are getting 12 months time to get more into the invention. You can also claim, you can also read, you can also have more experiments, so that this 12-month time can be used beneficially by you for having an effective approach, and for having an effective approach of getting a good claims in complete specification. And you have on your mind that, even if it is taking 6 months, 7 months time, you have your priority date fixed, that is of 1st February, as I told you, right? So you understood what is provisional and what is complete specification, right? Coming on to this complete, as I told you, within 12 months, more than one provisional application specification can be filed. Let's say if you filed on 1st February, you can file again on March, you can file again on June, July, whatever you are thinking, you can file it out, right? And when you are filing the complete specification, it's very important to understand that when you are filing a complete specification, all the provisional specifications, even if you are filing 10 provisional specifications, all the provisional specifications can be clubbed into one complete specification, right? Understood? So ultimately, when we are trying to deal with the complete specification, always remember that even if you have filed 10 provisional specification, the first provisional specification is your priority date, is your earlier filing date. The term of patent will be from that priority date. You have to make yourself very clear into this, right? So merit, priority date, as I told you. Cost, provisional specification is of less cost. So ultimately, let's say if you have conceived your invention, and if you think that, okay, fine, this invention can be very beneficial for me, so now you can go for a provisional specification. Cost is less. So if you are going directly to a complete specification, there can be a huge cost for patent, right? So for getting less cost and for analyzing what an invention is, provisional specification is the best idea to go for less cost. And also a very important thing is that you can put a tag of patent pending, that is also given by the Patent Act. Demerit, the more important thing is that when you are not able to file a complete specification within 12 months, as I told you, the complete specification within 12 months has to be filed. If you have not filed, the patent will be abandoned. So now, after 12 months, if you have not filed a complete specification, you cannot even claim the priority also. Your priority is gone, your everything is gone. So you have to be very clear that 12-month period has to be appreciated, and 12-month period has to be obeyed, and has to be filed within 12-month period, because then you will be having a abundant. Your patent will be abundant, substantially similar. Now, this is also a very interesting phenomena. Uh, when you are trying to deal, let's say I will give you an example. Let's say you are making a vegetable. Just taken as an example only. Let's say you are making a vegetable. So provisional specification means that you know which vegetable you will be using for making the whole meal, right? You say that, okay, fine, I will be using 5 vegetables, 6 masalas, and other thing, right? This is the provisional specification. Complete specification is when you are putting the meal all together. The more important and the demerit can be is that when you are in a provisional specification, and when you wrote in the provisional specification that I will be using only 5, you don't have to disclose everything, just a small disclosure of your inventive steps are there. So you said that, okay, fine, I will be using 5 vegetables. But in this 12-month period, when you are experimenting yourself, you think that no, I have to use 7 vegetables. So this demerit is there. The provisional application, if it sees that you only set 5 vegetables, 7 vegetables cannot be used. Means the provisional specification bars your complete specification. You cannot go beyond what you have written in the provisional specification. That's the demerit of provisional specification. Is if you have written 5 vegetables, 6 masalas, then you don't have to go beyond this when you are putting up a meal or other a complete specification, right? And the grant will not be over the or the will not be on the claim or the provisional specification. The grant will be on the claims of the complete specification, and after this the whole process of publication will start, right? So this is what a very important phenomena of provision and complete specification is. To the attendees, I will also say that we have 2 more applications. We have at least 4 more applications: convention applications, PCT applications, patent of addition, division applications. So provisional and complete, you understood, right? PCT and the convention application I will be getting into at the last of my presentation. Just for the sake of our understanding, what are all the patent of addition and division application? So patent of addition is something which, as the name suggests, when you are having some modification, when you are having thinking some improvement in the patent, you file a patent addition in the controller office under section 54, 55, 56. This is something which has to be filed after the grant of patent. I'm just telling for the sake of understanding. If anybody asks you what are all the different types of applications in patent, you are able to understand, okay, fine, it is provisional, complete, addition, divisional. So when you are trying to deal with an addition, patent of addition, you are filing an improvement, or rather we can say modification of a patent. That is after the grant of patent, right? So this is what is called as a patent of addition. When we deal with the divisional application, it means that you are having one invention. Let's say you file a complete specification, you are having only one invention, right? But after, while examining your complete specification, the controller is of the view that even if you are having one invention, but in that particular one invention, couple of different inventive steps are there, right? If he is of the view, or even if the applicant is of the view, then you can file division application. It means that you are dividing your application into 2 or 3 parts. That is also a good measure to have a good a strong protection of patent. So this is what division is. Divisional application, dividing our application. A mere division of a provisional specification, don't get confused by the division of provisional specification with that of division application. Divisional application is only being given by the controller when he understands, or when the applicant understands, that even if there is one invention only, but it constitutes different inventive steps, right? There are different things that can be taken care of. So you are getting into a division application. Well, provisional and complete are the important things that you have to understand right now. I just, for the sake of understanding, I just give you the analysis of what is patent of addition and division application. So date of filing, priority date, provisional and complete specification. If anybody has any confusion or wants me to repeat it, please let me know, because then we will move on further to examination.
There there are some questions. Let me just
Yes,
quickly
please.
check through them. Is selecting is selecting the priority date based on the discretion of the person who is filing multiple applications?
Pardon?
Is selecting the priority date based on the discretion of the person who is filing multiple
No.
applications?
It's not a discretion of the multiple application. this is very clear funda that even if you are filing the multiple applications, it's not on your discretion. Then tomorrow everybody will come and say that the last of my filing date is having a priority. The priority date is the earliest filing date. Even if 10 applications have been filed, the priority date will be the first filing date of your first application. It's not the discretion of the applicant.
All right, there is also a request to repeat the division application. I
Okay,
don't know
so
exactly. Yeah.
yeah, so division application. Let's say if you let's say I give an example of vegetable. So they take this as an example. When you are trying to deal with this, you have 5 vegetable and you have a meal, right? And controller think that okay, fine. If even if you have a meal, you just distribute this 2 vegetable here, 3 vegetable here. You can form two different application format. Rather, the meal is same, but it can be done. There are chances that you have a same invention, but that invention is interrelated with that same invention which you have filed. So in this case, division application is being granted. It means that your inventions is one, but something is there in your applications which is related to one or more aspects. So the controller can request you to file a division application. Since you have two or other aspects of invention, you first just file a division application. Don't think that these two division applications have two different priority dates. This is only one applications only. Our whole patent application is only one, but you are dividing your application into two parts because of the fact that since two are constitutes different way of getting into an inventive steps. That is what a division application is. I think it is clear right now.
Yes, there are no further questions, so I think we can go ahead.
Okay, so now the thing is that now I will be getting into the examination process, right? So examination is very easier to understand, and examination is very basic. Request of examination has to be made by an applicant or a third party for the examination within 48 months. Now, if you are having a patent application, you know everything is done, your complete specification is done, your priority date is done, right? Everything is done. You have cleared with all these things. Now you are getting into an examination process. What happened after publication, right? So publication has to be done within 18 months. Examination has to be done within 48 months of your priority date, the first filing date, which you have right now, which you are clear with. So request of examination has to be done with an applicant. You have to be very clear that if the request of examination is not there, and if the examination request is not been filed by the applicant, the patent application is deemed to be withdrawn. So examination process is not an automatic process. It does not mean that you will go and you will file a patent application and then automatically there will be having an examination. No, examination is a process whereby an applicant has to file. Why I said third party? Patent office also provides freedom to third party or to any person, even if an invention is there and even if I saw that it is published in the patent office, even a third party also get the right to have an examination request. Why this is so, I will be dealing when I will be dealing with the pre-grant opposition. So for the sake of as of now, you just keep clear that applicant and third party both are having the right to go for an examination, right? So a request of examination is done earlier the examination, and earlier the request, earlier the examination. One more thing very important is the provision of expedited examination, right? So I wrote after request the examination is done, earlier the request, earlier the examination. But provision of expedited examination is also available for those people who are either startup or who are coming for a PCT application. PCT application I will be dealing further. But when you are a startup and when you have filed a patent application, then you have getting a right to you are having a right to for having a expedited examination. Expedited examination means you are having your examination at a very faster manner. So this process of expedited examination is only being given to the startups and the PCT applications, and a couple of more. There are a couple of more categorization under rule number 24C of where patents rule 2018 or 2003. Both are having that similar provisions. So examination is clear. You have to make the request earlier the examination. You are not a startup. You are not a PCT applicant. So you don't have the right to get an expedited examination, right? You have to be clear about this. And controller will then refer to the examiner who will then provide the first examination report, and then applicant have to go and have to reply. If there is any objection in the first examination report, the applicant has to go and has to reply this FER within 6 months, extendable till 3 months. So 9 months is the time duration which is given to the applicant to reply the FER, right? So this is a basic funda of what examination is. More important, what is more important to understand is an opposition process, right? This take time. So when you try to deal with this pre-grant and post-grant opposition, so two types of oppositions are there, like pre-grant and post-grant opposition. Like in trademark, we deal with the objection and opposition. It is similar to that only. Pre-grant, as the name suggests, is something which is an opposition before the grant of patent, and post-grant is an opposition after the grant of patent. So how is this pre-grant and post-grant differ? Almost the ground for pre-grant and post-grant are similar. In section 25 clause 1 and section 25 clause 2, it is being specifically mentioned, the grounds. Almost they are all similar, but pre-grant 25 clause 1, post-grant 25 clause 2, right? So pre-grant is anytime before, as I told you, anytime before the grant of patent. Let's say if you are having granted, the patent has been granted, then you can go for a post-grant opposition, right? Now the thing is, any person can file pre-grant opposition in the office of the controller before the grant of patent. Now, the important part comes up here, that when is there is a person or any person and person interested, it means the patent rule and the patent act gives the independence to any person. Any person means whosoever is, even if he is not related to the invention also, any person can go and file a pre-grant opposition. This is the freedom that is being given by the patent office, that any person can go and file a pre-grant opposition. While when we deal with the post-grant opposition, it is written person interested. Person interested has been specifically mentioned under section 2 clause 1T, whereby what means that you are person interested only when you are having some you are engaged in that research, or you are promoting that research. So pre-grant, anybody can file. Post-grant, you have to prove that you are a person interested in this area. Now, pre-grant, any person is interested. The rule number 55 of Patent Rules 2003 says that the controller cannot take a pre-grant opposition until and unless a request of examination has not been filed. Now link this with this examination. I told you that request of examination has to be filed by an applicant or third party. Now let's say if an applicant is there, the patent application is there, it is published, but the applicant has not filed any request of examination. And in the pre-grant opposition, any person can file a pre-grant opposition before the grant of patent. That is why the request of examination has been given to the third party, because I will not wait for the applicant to file a request of examination. If I see the patent office journal, and if I see that, okay, fine, this invention is infringing my invention, I will definitely go and I will definitely file a pre-grant opposition. I don't have to wait for that request for an applicant. I also have the right to go and file a request of examination. You understood that, right? So that is why request of examination has been given. The process of request of examination has been given to both the applicant as well as third party, so that third party should not sit and wait that, okay, fine, let's wait when the applicant will file a request of examination. Even you can go and file a request of examination, right? Pre-grant is, since there is no fees for pre-grant opposition. So post-grant, as I told you, 25 clause 2, post-grant opposition has to be filed within 12 months of the grant of patent. And as I told you, the concept of person interested, the person interested is written in section 2 clause 1 T, and more important, constitution of bench dealing with the post-grant opposition. You don't have to get confused. The controller in a pre-grant opposition can see the case and can also decide the case based on the merit. But in a post-grant opposition, since it is a person interested, the controller is deemed to have a opposition board, in which the opposition board will see the post-grant opposition and all are the intricacies of what are all dealt within this post-grant opposition is, right? So pre-grant, post-grant. Pre-grant before grant of patent, within 12 months of grant of patent. A pre-grant, any person. Post-grant, person interested. Pre-grant, 25 clause 1 grounds are there, post grant 25 clause 25 clause 2 grounds are there, right? Clearly and clearly understand this whole concept of pre-grant and post-grant, right? So now cutting further, what happened when you are having what are the remedies when is your pre-grant opposition is cancelled or is accepted? Before getting two cases, Novartis AG was in Adco Pharma. These two cases are an example why pre-grant is an important part in patents, because in these two things, pre-grant was successful, and Novartis filed patent, Adco filed pre-grant opposition on ground of prior publication, lack of inventive steps, and controller accepted the pre-grant. Right. So these are the successful pre-grant. Pre-grant are always successful. Mostly they are successful because before even before granted of the patent, you are getting the right to even oppose it, right? And specifically in Hindustan Lever, Hindustan filed a patent application, Godrej filed opposition, controller through the pre-grant opposition ordered amendment to the specification, right? So this is what the importance of a pre-grant opposition is. Now, important part is remedy. Now, let's say you say you gave an example, a pre-grant opposition in the patent office, and as I told you, there is no need and there is no necessary part on the controller to call you. Even the controller can decide on the basis of the merit also. There is no whole sole rule, or there is no specifically rule that is being given whereby the controller has to call you and has to hear you. The controller can hear and can decide the pre-grant opposition on the basis of the merit. You have to be very clear on this, right? So since you are not getting anything and you're not getting any let's say you are not getting any hearing procedure in the pre-grant opposition, then what are all the remedies? Now, pre-grant failed. If your pre-grant is failed, even if, let's say if I filed a pre-grant opposition and my pre-grant is failed, it means that the patent applicant won, right? My pre-grant opposition is failed. What are all the remedies with me? So if I am a person interested, let's say, so I have a remedy of 25 clause 2. So I have to wait till 25 clause 2, till the grant of patent, and within 12 months I can file a post grant opposition if my pre grant is failed. In the post grant opposition, I will be getting a whole issue of opposition board and everything I will be getting. So if a pre grant opposition is failed, you are always have a remedy to go for a post grant, but you have to wait for the time the grant of patent is there, right? And section 64 is revocation of patent. In this revocation of patent, you can go and you can just file the revocation of patent. Revocation of patent can be filed within the time frame of the grant of patent. It means within 20 years of time frame, you can file the revocation of patent at any point of time you feel, right? So this is what is revocation of patent, and 25 clause to the remedy for a post grant pre-grant if failed, right? Now, what if I will come to the case law. What if pre-grant is succeeded? It means that it means that patent application lost, and the pre-grant, if I am giving the pre-grant opposition, the patent applicant is lost, and the pre-grant person who is filing the opposition won. Now, what is the remedy with the patent applicant? Now, it has to be made very clear in Yahoo versus IPAB case that when you are having a pre-grant opposition, and when the pre-grant opposition is succeeded, the controller gives a judgment or gives a decision not in favor of the patent applicant. It has to be made very clear that the order of the controller is deemed to be under section 15. Section 15 of the Patent Act, which is specifically deals with the order of the controller. So this order of a controller that your pre-grant opposition is good and your patent applicant is rejected through pre-grant, not post-grant, through pre-grant, this order is deemed to be under section 15, and under the Patents Act, section 117A of the I know it is very confusing, I will repeat it. Section 117A gives you an authority and gives you a right to appeal to IPAB, Intellectual Property Appellate Board. So again, I am repeating it. Let's say if I am getting into a pre-grant opposition, and if my pre-grant opposition succeeded, right? So Mr. X, who is a patent applicant, is devoid. He is rejected. His patent applicant is rejected. So the controller orders that the patent applicant is rejected. Now we cannot go further since pre-grant is all right and it's fine. So what right Mr. X is, Mr. X can take this decision of the controller under section 15. So it means that the decision of controller in the pre-grant opposition, even if it is even if it is a pre-grant and even if it is a controller decision, it is deemed to be an order under section 15. And in section 117A, which talks about appeal, section 15 is applicable. So you have to link section 25 clause 1 with section 15 of Patents Act and then go to section 117A. This is a long process which we have to go. It was decided in the case of Yahoo versus 𝗫𝗄𝗃 that this is what the order, standing order of controller is an order of is an order under section 15, and which hence it can be appealed under section 117A. So ultimately what happened is the applicant is at a better position, because even if pre-grant opposition is your pre-grant opposition is cancelled, right, you failed, so you have to wait till the grant of opposition and then you go for a post grant, or either you go for a revocation. But as soon as the controller will order against a patent applicant, he can directly go to under section 117A through 15 and appeal to an appellate board, right, 𝗫𝗄𝗃. That is what the whole issue is. In UCB 𝗪𝗳𝗃 versus 𝗃, the same case was dealt under, in which the court says that any order of refusal of patent application is appealable to 𝗫𝗄𝗃. The controller reject the patent application in pre-grant, the appeal to 𝗫𝗄𝗃 is specifically mentioned, right? So this is what the pre-grant and post-grant opposition is. The remedy in terms of pre-grant and post-grant opposition. Sorry, not post-grant, pre-grant. What about post-grant? Since I am not dealing with the post-grant, because post-grant is very simple. In section 25 clause 2, when there is a post-grant opposition, the post-grant opposition is very simple, because the opposition board will give you the result. After getting the result in your hand, if you are an infringed party, if you think that the decision is not in favor and you think that something is wrong, you can file. Both applicant as well as the post grant opposition, the person who will file the post grant, both have the right to go for an 𝗫𝗄𝗃 decision against the post grant opposition, against the decision of the opposition board. So post grant is fine, both parties have the right. In pre-grant, there is some confusion. There always been some confusion why who has the remedy and how the remedy has to be exercised. This is very confusing. So I think if anybody has any confusion till now, I will repeat it once again. Akshay.
Just a second. A complicated invention is explained via division. So a complicated invention is explained via a division application.
So what, sir?
That is the whole question. So through a division application,
is given through divisional application.
Yes.
No, you are not having the right to file a division application first. You are having this is the point. I think the question should be the complicated invention can be divided into various division applications, right? So in spite of having a complicated invention, you are giving a one complicated invention. Either controller or the applicant. Suppose tomorrow if I am filing the division applications, either the controller, and it is complicated, either the controller or even if applicant wants, I can divide these into 2 or 3 division applications and thereby get into a and can go further with this with my application. So this complicated invention can be divided into division applications as per the requirement of a controller or the applicant.
Another question is, in pre-grant opposition has no right to appeal if the decision is in favor of applicant. Does the pre-grant opposition has no right to appeal?
That is what I want. I was explaining that in pre-grant opposition, if the decision is in favor of the applicant, applicant means the patent applicant, right? So you as a person interested has to wait for getting into a post grant. In UBC 𝗪𝗳𝗃 versus 𝗃 and in a couple of more cases, as a pre-grant opposition, you don't get a remedy instantly. You have to wait. If you are a lost party, if you lose the pre-grant opposition and the patent applicant won, you have to remedy. Either you have to wait and let the grant of patent be done and then go to the post-grant opposition, or you go for a 1664 revocation of patent. So they don't have any remedy. The applicant, if it is decided in favor of the applicant, the The pre-grant opposition, the person who claimed the pre-grant opposition doesn't have any instant remedy, but he has a remedy in future. He can go for a post-grant and revocation. Whereas an applicant, if the decision is in favor of a pre-grant opposition claimant and not in the applicant has a remedy to go under section 15 117A, right? So I think this is clear right now.
Yes, that was all.
Akshay.
No questions further, sir, as of now.
Okay. So I will move forward with this opposition only. Probably I have made you all understand what are all the things. So I think this is just a repetition of what I told you right now. Post grant opposition constitute an opposition board. I told you a board has to be opposed. The constitution of an opposition board has to be there in post grant opposition and not in the pre grant opposition. Pre grant opposition, again I'm repeating, controller can even decide the pre-grant opposition on the merit without even calling. If he wants that, he don't want to call the party, he can decide on the merit. But in a post-grant opposition, the constitution of a bench is there, and that is why the reason is that in post-grant opposition, I told you, person interested. It means that you won't get any frivolous application tomorrow. In pre-grant, you can get any person, right? Even if I don't know what is the pharmaceutical agent, but a pharmaceutical compound, but even if I want, I can just file a pre-grant opposition. But in a post-grant opposition, I need to prove that I am a person interested. How I need to prove? I will be proving that I am researching into it. I am engaged in this particular field. You need to prove it. That is why this is such a strictness is the strict approach is maintained in the post-grant opposition, and that is why the constitution of an opposition board is being given. That whole opposition board is there, 2 or 3 members will be there who will deciding the whole issue of your opposition. 25 clause 4, as I told you, hearing opportunity being given to the controller can either grant. Hearing opportunity is also given in post grant. You have to understand that is why in 25 clause 2 you will see that person interested, because they don't want to get any frivolous application, and this post grant is very important and is very strictly maintained. That is why they are very cautious about who are all are filing the post grant. There should not be any frivolous applications because the process is very lengthy. Even if they are time bound process, but it requires a very lengthy process, right? And post grant is also a fee. Like I told you, pre grant has no fee. You can just file in free of cost. Post grant is having a fee, requisite fee. So all things becomes very important as soon as the procedure established. And in post grant, both opponent and patentee have the right, as I told you, 15. In a post grant, the decision of the controller will be treated even if it is against applicant or even if it is in favor of applicant. The decision will be treated under section 15, hence appealable under 117A. But in pre-grant, I repeat, in pre-grant, the decision in favor of an applicant, in favor of an applicant will not be appealed and will not be treated under 15, but a decision not in favor of an applicant will be treated under 115, hence appealable 117A. This is something which is very confusing, but you have to make yourself very clear. Again, explaining in one line. Pre-grant opposition. Suppose A filed pre-grant opposition against B. B has an applicant. Let's say A won, B lost. B is an applicant, patent applicant. B lost. Hence, B, a patent applicant, can go through 15, since the order of revoking the patent right of B will be an order under section 15, hence appealable under 117A. But if a decision has been given to, let's say A, and let's say against A has only a remedy to wait till B get a grant of patent and can again go to a post grant opposition, or he can go for a revocation, right? So this is a long process for all the pre-grant opposition personnel. Applicant is always in a beneficial position. In a post-grant opposition, you have to be very clear, either A or B, both have the right to go to an appeal to an appellate board 117A. This has to be very clear. Now, this was the opposition examination. Again, I will ask if anybody has any confusion. Again, I will repeat it. Akshay.
No questions yet as of now.
Okay, so now you understood the date of filing, you understood the priority date, you understood the provisional complete specification, you understand the patent of addition, you have clear analysis of division also. Well, patent of addition and division is not much important for us right as of now, patent provisional and complete specification is of much important. You know, date of filing, priority date, examination, pre-grant and post-grant. You know the remedy also, that how to go ahead if you are having a pre-grant opposition and a post-grant opposition, and what are all the remedies. So this is what is this is all the main constitution of all sort of what you are getting into a patent application is, right? So examination, pre-grant opposition, these are all the applicants used to face all these type of procedural nitty-gritties, and you have to be very clear. All are very time bound, and all times are being mentioned in the whole issues of the patent rules and other aspects. So these are all the very time bound applications, and any person, if a person is interested, as I told you, any person pre-grant, person interested post-grant. So this is what a conceptual analysis of what is how to go ahead with the patent application is. Another aspect comes of is of PCT application. This is called as the Paris Convention Treaty, right? So what is all about PCT? Sometimes this also becomes very confusing. People try to link this PCT and international treaty and international patent application with an Indian patent application. So first of all, you have to be very clear that an intellectual property is a territorial in nature. International patent application or other international patent filing does not mean that you have a patent right on the whole world. It's just named as an international patent application. It does not mean that you don't have you do have the monopoly over the whole world, or rather you have the monopoly over the contracting part states at least, right? So it is an international treaty. Before getting into the date and timelines, I will just try to explain you that. Let's say if you are having if you are having a, let's say, invention, and you know that this invention can you are very much into in a belief system that okay fine, your invention can get protection, and your invention should also be, I should also file this invention in Australia, Canada, or Russia, wherever you want, right? So you think that okay fine, let's go for a PCT filing. So what happened in PCT filing? First of all, you will go and you will register yourself in a regional patent office, right? What is regional patent office is, we all know, all the regional patent office in India or in any country you are finding, there are all the regional patent office. You have to be very much clear again that each contracting states have one regional offices that constitutes the PCT office. That is PCT office. It means since we have patent office in Mumbai, Chennai, Kolkata, Delhi. But if you are wanting to go for a PCT filing, you have to register yourself in New Delhi, right? So you file a PCT application in New Delhi. All the diagrams will be there. I will be showing you all the diagrams to make you very clear about all these aspects. So you go for a filing at regional patent office, that is Delhi, right? So what is your benefit? What happened is that when you file a regional patent office, in a regional patent office, a PCT application, your filing of this regional patent office directly comes make you in an international arena. Thereby, let's say you have filed it. Now you will be having an international searching authority, an international preliminary inquiry, and all sort of things will be there, which will give you whether your patent is eligible or what is your patentability. Again, I'm clarifying it. You are filing it in India. You have that publication, examination, all of these things are there. In examination, the report, first examination report, as I told you, everything is there. Similar process has been applied in PCT also. What is an importance of this PCT is that when you are getting into an PCT, you are giving a international search authority. So ultimately, what happens is that when you are having a report from an international search authority, all the contracting states, all the states which are having a connection with PCT, they know which applications and which all are things being listed in the international publications, right? So only the benefit is that you are getting global. You are getting a chance of getting yourself into a global phenomena. You are getting into a system that okay fine, no India will not do my international search, my search, but it will be done internationally. It will be like whole world type international search, right? So ultimately what happens is when you are getting into a PCT application, you are getting an international search, you are getting an international publication. So the scope of your invention ultimately exceeds it to a level of more than a territory level, right? So what happened? PCT application is there. You are going into a PCT application, you are going into an international application, you are getting an international search, and you are getting an international publication. So this is what beneficial is for your patent innovation. I will explain you further in this line in the another slide. Like PCT application automatically bound the contracting parties with an international filing date. Let's say you have filed your regional patent office on 1st January 2021. So in Delhi, you filed your let's say in Delhi only you filed your patent application on 1st January 2021. The Patent Act gives you a right to file a PCT application within 12 months. So 1st January 2021 till 1st January 2022, you have the whole period of 12 months to file a PCT application. Let's say you file it on 1st June 2021, within 6 months time, right? You filed it within 12 months time, even after 6 months, right? So your international filing date will not be 1st January 2021, but it will be 1st June. There used to be very confusion in all these international filing and priority date. You are having a date of 1st June 2021, not of the 1st January 2021. The 1st January date is your priority date, but your international filing date is your 1st June. So when you are filing a PCT application in Delhi, you are claiming your priority. Again, coming to the first slide where I analyzed the date of filing and priority date. Priority date means you are establishing your invention, you are establishing your innovation. So when you are filing in on 1st June 2021 in Delhi office, the PCT application, not the regional application, not the patent application, the PCT application that has to be filed within 12 months, you are claiming priority on 1st January. So let's say if somebody else come in between that whole issue of, let's say if somebody else files an application with having same inventive steps on 3rd of March. So your PCT application will prevail over other because you have the earlier filing date and you have an earlier priority. So this has to be made very clear, the international filing date and international and the priority date. So you file a PCT application with the regional national office or WIPO. You have also the right to go for a WIPO. So I give an example of India. So you file a regional patent application in India. Within 12 months of time, you also file a PCT application. You want to go global, right? So your international search authority will check your patentability. As I told you, you will be checked by international search authority. You have an option and you have a full freedom to choose your international search authority. There are a list of international search authorities. Obviously, they are countries only, but they are all experts level from all over the world, which sees that your application is there or not. So you can choose international search authority as in India also. You can choose China. You can choose USA, Russia, wherever you want, right? So international search authority you can choose, and that publishes a written opinion within 16 months from the local application. Now you have to be very clear. The timeline that has to be done, right, is from a local application, not of an international filing date. I repeat it again. You filed it on 1st January and you filed a PCT application on 1st June, right? So your filing of all these things, like I wrote within 16 months, within 18 months, international publication, international search authority, these all will be calculated from 1st January, not 1st June. In spite of the fact that you are having the 1st June as an international filing date, but a PCT calculates every timeline from your local application. That is the application from which you have filed in the, as for our example, the 1st January. So this is what the difference between international filing and international filing date and the priority date is. So all the timeline has to be maintained within that issue only, within that regional application date only, that is of 1st January. What is more benefit to those applicants? Let's say uh, you are getting a PCT, you are giving into a PCT applications, and you are thinking, okay, fine, you should file a PCT application on 1st of June. You file a PCT application, right? Now within 16 month and 18 month, you filed a you get a international search authority, and this publication has been done within the timeline. They are all very prompt, and the timeline is always maintained. So this is done, right? So when you are trying to deal with your application further, now you think that, okay, fine, should I file it in Canada or Russia or Australia? Means after the PCT application is done, after your international search authority and international publication is done, you have the right to again file a national phase registration, right? So you have done with this international application, you have done with the international search, you have done with the international publication. I told you that the patent rights are territorial in nature. Just by mere having an international search does not mean that you get a monopoly over your invention in the whole world. It means that you are getting into the application, you are getting into this application in a term that after 18 months or the international publication, you are also getting some time to think that, okay, fine, now I have got international search, now I have got international publications. Even if you filed in India, no issues. You can file anywhere in the world, only the contracting states only, but naturally, that which application and where you have to file, which is called as national phase registration. Means 31 month is the time duration from the local application. Thereby, what does that mean? Is when you are trying to deal with this application, when you are trying to deal with this PCT application, when you are trying to you have got this international search and you have got the international publication, the whole issue of PCT application comes down when you file a national phase registration. It means that if you are getting into a national phase, you are getting the national international search authority. Now you are getting time to think that, okay, fine, now I have international search authority. Now where should I file? Like Japan, Canada, USA, America, where should I file? So you are getting a national, after the completion of 30 months, the applicant and enter into a national phase wherever he wants to apply. So international search, again repeating, international search and international publication does not mean that you are having a patent over your invention. Again, you have to enter into a national phase. This is what I want to make you understand. Again, you have to make yourself and enter into a national phase. If you want to have a patent in India, you have to go again to international for Indian office, and again you have to file a PCT application in national phase. So this is what the whole issue of PCT application is. People, there is always a confusion with regards to an international patent filing. The patent is always regional in nature. PCT only helps you to get yourself a global outlook, meaning thereby an international search and international publication. Again, you have to enter into a national phase only for getting yourself registered into a national domain like India, Japan, or anywhere else. What happened is PCT provide you a 30-month time to check essays and see that which country will be suitable for you in filing a national phase. That is what a very powerful argument, and that is what a powerful merit of PCT is, that you are getting 30 months time to assess, to seek inventor, to seek things. You have the international search authority timelines. Everything is you have everything. Now you are getting time, and you can just see which country you have want to enter into. So this is what the PCT filing of 30-month duration is, right? So PCT is different from convention application. Now, what is convention application? There is a Paris Convention. Since this is not being, I will not be dealing much, but as part of your understanding, there is a Paris Convention, and there are countries under Paris Convention. So what happened is when you filed a regional, let's say you filed in 1st January, within 12-month time, you can file a foreign application within 12-month time to all those countries under the convention route. Right. So 1st January 2021, you filed your regional patent patent application. Within that 1st January 2022, you have to file a convention application. You can file within 12-month time. Why PCT is important? This 12-month time is extended by 18 months, since PCT gives you a right to file a national phase in 30 months. So that you are getting 18 more months than the conventional route to file your application in wherever you want. And even you are getting an international search authority, international search publication authority, everything you are getting, right? So that is an important part for PCT, thereby which you are getting more time. You are getting an international search report, you are getting an international publication, and you are getting, even the more important is the more than 30 months, right? 18 more months to enter into a national phase. The term of PCT will be 20 years from the international filing date. Again, let's say you have done your international search authority, you have done your international publication. Now you want to enter into a national phase, as I told you. So you think that, okay, fine, let's go to India only. So now the procedure will be same. Don't think that you are having the international search authority, you are having the international publication. the procedure will be no for you. It will be very fast forward. Yes, it is an expedited examination because all things are there with you. You have the search authority, you have the things. But similar process like examination, everything which we discussed is will be applicable and which will be applied in the present scenario, right? So be very clear. You don't get any right, you don't get any monopoly, just you get an international examination whereby you can understand and you get time for 30 months to understand which country should I follow. This is the I think the best advantage that PCT have, right? And even if you are getting into a national phase like you are coming into in India, then your filing the term of patent will be 20 years from international filing date, meaning as I gave you an example of 1st June, the national phase, you enter India, the patent is being granted, your patent term will not be by 1st January, which you file in the local application, but your local area which we discussed, but your term of patent will be calculated by 1st June 2021. So this is what an advantage of PCT application is, right? A term of convention filing date is also 20 years from the date of filing in India. So that is convention is not a part of discussion. So this is what the PCT filing is, right? So this is the whole what I make you understand with all these things. This is the graphical representation. You file a local application 0. You file a PCT application within 12 months. I told you within 12 months you file the PCT application, right? Within 16, you have the international search report. Within 16 months of 0. 0 means you have local filing. 1st January, which I told you. Within 16 months, you have the international search report and written opinion. Within 18 months, you have international publication. These two things, request of supplementary and supplementary search report, international and everything are optional. You can do it, but it's you can pay the fees, and you can also, if you think what are all the I will tell you. Let's say if you are having an international search report, you think that you require more deeper search, you require more something more, right? So you can also file an application to supplementary for an supplementary international search, thereby which will help that they will provide you a different and another search for the PCT application, right? So international search report is fine, but if you want you want to go something deeper, then you can also request for a secondary or supplementary international search. It is an optional, no need to enter, no need to worry about it. And then 30-month international phase. So even if you file in Delhi, you file a local application, you file a PCT application in Delhi, and after getting in international publication, you think that your application is very good for Japan, you go to Japan, no issues, you can enter Japan within 30-month period. 30-month is always variable. US follow some country follow 30 month, India follow 31 month, right? So 30 month is the time duration to file a national phase registration. You have to enter the national phase registration, right? As I told you about PCT, you file a local application 0, and within 12 months you file application abroad. So in convention, neither you are getting an international search report, neither you are getting an international publication, and you are getting only 12 months to file application abroad. Here you are getting 30 months. So that in spite of getting 30 months, you have also in your hand international search report and international publication also. So this was the primary very clear concept of PCT. I think if you are able to understand this graphical representation also, I think you will never be confused, because this PCT application, PCT filing date, and all these things are very confusing in nature. And also sometimes even in some of the examinations, they asked questions that, okay, you filed a patent application on this date, you filed a PCT application on this date, and then you go to India and then you filed a national phase application in India, then what will be the term of your grant of patent? So people get confused. People try to calculate the term from the priority date, but it is wrong. You have to calculate the term from the international filing date, that is the filing date of PCT. These are all the small intricacies, things and nitty-gritty which need to be addressed and which need to be very clear about when we are dealing with this patent application as an advocate or as a student also. Because when you will try to, if you are a student and if you are giving examination and if you try to write all these things with an example, as I told you, definitely you will get good marks. So this is what the PCT application and PCT filing and the timeline duration of PCT is. Last but not the least, as I told you, this is the whole process. Application for patent, publication 18 months from priority date all knows, request for examination 48 months, examination, formal, substantive. You formal and substantive is nothing but only the subject of, like in substantive, the controller will go into a deeper examination, and a formal means an overall examination, and the upper part of an informal of examination is there in a formal and substantive one. After formal and substantive, if application found under order, grant by controller, yes, patent granted, no, patent refused. Again, if patent refused, appeal to appellate board. These are all the chart, I think you are able to understand. Pre-grant opposition after publication, but before the grant of controller, again coming, the arrow comes here. And if it is yes, then patent granted. If it is no, pre-grant opposition is no, then patent refused. Again, patent refused, as I told you, in pre-grant opposition also, the patent applicant has got the right to appeal. So this is very much there with this one. You are getting a right to appeal to appellate board. Patent allowed, granted, not allowed, rejected. Again, you can go for the IPAB or something. You can also go for the writ petition also, which is not mentioned here. So you can go also the post-grant opposition, order by controller to maintain the patent. All these processes have been discussed, right? So this is all the whole process which we discussed in a glimpse of what you can understand, right? So this has to be keep clear in your mind. What are all the things, right? And the PCT filing has to be very clear that what are all the dates and timelines, and how to calculate your term, and how to calculate, and what are the difference between the convention route and the PCT route. And this is the whole process. So I will end up here. I think it's more than enough, Akshay. And if anybody has any confusion, please let me know. And I will also repeat if anybody has any confusion in this.
There is one question. Is there any timeline for filing PCT application after filing application in regional office?
12 months. You have
All
12
right.
months time to get into a PCT filing. 12 months time. As I told you, 1st January you file a regional. Within 12 months you file a this one PCT filing. The 1st January or 1st June, like that only.
All right, all right. So I'm not seeing any more questions as of now. Uh, there is a question regarding book suggestion. If you
Books
suggest
is
any
something which
book.
I never read any books. To be very honest, I used to go to the official website of WIPO, go to the official website of IP Watchdog, USPTO, and understand from there. To be very honest, my concepts are very clear because I never get into books. I always used to go for the websites of official websites, right? So they make your concept very clear. I cannot refer any book right up now.
Right, right. So if you can smartly use Google, you can get
Huh.
whatever you want, right?
I will suggest
Whatever
if you
you
want
want.
to understand PCT as well as all other applications, go to WIPO site and there are PCT frequently asked questions. They have explained PCT in a very well manner. I think all books in India copy from there only. My chart is also
Right,
from WIPO only. So this is
right,
something which is very important. Yes.
right. Any more question?
Yes.
Any
If you
query?
want anything to repeat also, I will repeat because I know this is very confusing. Very confusing. I will also write my, I think, this email ID so that if anybody wants to mm,
Reach out to you. Yes.
connect, connect me.
So you can see his email ID on the chat box here. You can reach out to him at this email ID. With
I
this,
think this is not. Oh, 1 minute. This one.
all right.
Yes, now you can see it because previous message was all panelists, not attendees. So yes,
Right.
now you can see it.
Any suggestion for drafting specifications? There is this one question.
Suggestions for drafting specification comes up when you are trying to before getting into all of these things. Any drafting specification will come before that. A suggestion is well, I what suggestion I could give? It's only about practice and it's only about seeing the previous granted patents, the claim, the titles, the abstract, and all these. In you will when you will go to section 10 of Patents Act, you can find all the specifications and all the things that you need to provide in our patent drafting: title, abstract, claims, inventive steps, everything. So you just need to follow all these guidelines in the Patents Act, and you can do. Regarding filing in language, people understand and people learn from practicing only. So yeah, but patents applications are available on the net. So I will suggest you to read those drafting applications as of now.
All right.
Scope of
One more question, if people can connect with you on LinkedIn.
Sir, I would like to know the scope of practice in IPR after. IPR is an emerging area. I think I think IPR. Yeah, you can go for IPR litigation. You can go for trademark. You can go for patent litigation also. I think if you're having the patent, if you're having the science background, then even you can go for a patent agent examination and also become a patent prosecutor in front of patent office. So all the patent application will be filed by your sign. As of now, we without any having a patent agent, you cannot file a patent application in the patent office, right? So you can have a lot. There are a lot of scopes for an IPR after LLB course. You can just join. There are a lot of firms also as of now dealing with trademark litigation, patent litigation, IP litigation, designs and other things, copyright also. Yeah, lot of scope. After corporate, I think this is becoming a booming industry.
Right, right. So I have put up his LinkedIn link on the chat also. What edge do law students gain against
Patent
other fields?
litigation is something like when you are trying to deal with the patent litigation, specifically, you are what edge means. I cannot say any edge because I used to deal and I used to refer to trademark litigations also. I used to refer to patent litigation also. I don't feel any competitive edge within that framework. But yeah, I can say that in terms of monetary benefits and in terms of let's say money involved, patents and pharmaceuticals industries have more impact over the litigation aspects as compared to trademark. Until and unless you are having a trademark litigation, if you are having a client like Google, Microsoft, trademark has a very less monetary or has a the money involved in the case in trademark is comparatively less than these patent litigation or other pharmaceutical litigations are as concerned. But as of now, I think that you cannot have any competitive edge. You are having a litigation, you can go in both of them. Both are having a respectable job.
Right, right. And to answer the question, if you're really looking to have an edge, then you need to know the skills to practice as a lawyer, right? Your skills can be your edge, right? If Do you think what I'm saying is right, sir?
Yes, sir. You are absolutely right.
All
Skills and
right.
skills only has to be developed by the practice. Like probably, I think that there are a lot of drafting courses. I think Lawsico is also coming up with a drafting course also. But even if you are taking the drafting course anywhere, until and unless you do yourself practice, you do yourself things. Because to be very honest, I never did any course of drafting, and I was very much upset by because I don't know how to draft. But I now I start understanding where I have to attach. Like if you are drafting your claims, you have to be very clear that because your claims will form your post grant and all sort of oppositions, right? Pre-grant and post-grant opposition. You have to be very clear. Your language has to be made very clear. Your language has to be very crisp, concise. So this is very important aspects, and this comes with the practice, which I feel so.
Another question is there. What do you think is scope for copyright law practice? I think that is what he means. What
Where,
about
sir? Why? Which one, sir?
this is on the question board? What about scope in copyright?
Copyright has a lot of scope these days when music industries and licensing are being booming industry. All these T series, Shimaru and other aspects, all other these big companies are taking the copyright lawyer. There are a lot of things in copyright also. Recently, I don't remember the exact case, but yeah, I think there was a case in which a big multinational, I think, press has claimed a copyright over all their work, which was cheated and which was available on the internet free of cost. So copyright has a lot of scope when you deal with this whole issue of music industries, or whether you want to go for a press, EBC and other. All these big companies are very cautious about their copyright. So these are they are like T series, and I think there are companies in Mumbai which are specifically dealing with this music industry licensing, music licensing, sampling, remix, and all these things. There are a lot of scopes, but for as you want to know more about copyright, then it's better to get connected with somebody who is having a media entertainment lawyer field. That is
Right, right. So as far as opportunities are concerned, if you can see, there is also a boom in online platforms, right? for example, Netflix, Amazon, etc. A
Yeah.
lot of content is coming on. So, lot many people are producing a content which will require copyright. So there is this increase in quantity as well,
Yeah.
right?
See,
There
leave
are,
alone,
so
leave
yeah,
alone others. Even 𝗨𝗪𝗀 is having such a type of drafting courses, and all other courses are there. So if tomorrow, let's say, if I start a company and I cheated 𝗨𝗪𝗀's all courses, then 𝗨𝗪𝗀 can claim my copyright. Exactly.
right.
That's a very valid point. They have a copyright on their own. So this is all. All this copyright also attaches a very amount of value. There are monetary conditions are very much in copyright also. One more, I think, why is it that IPR litigations are carried out only in Delhi, Madras, and few places, and not by all High Court? No, it's not. It's not the case. I think Bombay High Court and Calcutta High Court and all these things are also coming up. But why it is carried out? It's because only about the fact, which I understand, is that in Delhi, Madras, Chennai, Mumbai, all are IT hub, like Bangalore and all. These are IT hubs. So whenever their case arises, the basically we have to go for a high court, which is in that jurisdiction, right? So I cannot assume a very big IPR litigation being arising in Bihar. Right. I'm not saying that Bihar is not any is backward area, but I'm saying that not big litigation approach of IPR or trademark or patent comes from Bihar. So Patna High Court will not be having any jurisdiction. Not having jurisdiction, not no, but it will not having any case also. But in Delhi, all cases used to come in IPR because they are having the companies there set up. All the jurisdictional disputes are related to the Delhi High Court only. That is the reason why the place matters in a High Court practice.
Right, right. So I don't see any more questions here. We have overshot the time as well. So
Yeah.
it was, I think we can conclude this session. It was a very informative session. I think for everyone, people stayed back for until very end. Only
Mhm.
after it was concluded, I saw people leaving. So I hope that it was very useful for each one of the participant. Thank you so much for joining this webinar, and thank you so much, Saransh sir, for agreeing to do this
Thank you,
with
thank you,
us.
thank you so much. Thank you,
It was a
thank you.
great pleasure. We'll be looking forward to do more of such webinars. Please stay connected.